After a particularly horrific decision from the United States Supreme Court last month, ICE has taken that ruling and reduced it to a memo that it has given to its workforce this past Wednesday. But just within the last 24 hours, the Washington Post has gotten its hands on that memo and is reporting the following triage that is happening to people that have been rounded up and are currently being held in detention. And listen, we knew it was bad. And we knew that this ruling from the Supreme Court that allows deportations to third countries, meaning places from which these immigrants don't even come from. And let's go back to that decision for a minute, because I want to remind people about that. This decision was from last month, June 23rd, 2025. Department of Homeland Security versus DVD. That was the initials for one of the migrants that was in detention. And if you'll recall, there was a federal judge by the last name of Murphy who was in Massachusetts, and he had entered a stay or a block on this idea that people that were trying, the DOJ and ICE, et cetera, were trying to deport to a country from which they're not even from, right? This federal judge says, no, you cannot do that unless you give them basically fair, reasonable notice. That's not just like, hey, in a minute you're going to be deported, and an opportunity to be heard. I mean, this judge, Judge Murphy, said that these are the due process conditions that are required to be given to detainees before they are shipped off to a country from which they don't even hail. The United States Supreme Court said on June 23rd of 2025, that preliminary injunction, that's that stay that this judge basically said you're not going to be able to do to ICE. They said that preliminary injunction, guess what? Because there's an appeal pending in the First Circuit Court of Appeals, and if something happens where you petition for a writ of certiorari to the United States Supreme Court, we're going to allow those deportations to move forward in the meantime. So, you remember the outrage from that decision, right? And Justice Sotomayor wrote a scathing dissent, and this is how it began. In matters of life and death, it is best to proceed with caution. In this case, the government took the opposite approach. It wrongfully deported one plaintiff to Guatemala, even though an immigration judge found he was likely to face torture there. Then, in clear violation of a court order, it deported 6 more to South Sudan, a nation the State Department considers too unsafe for all but its most critical personnel. An attentive district court's timely intervention only narrowly prevented a third set of unlawful removals to Libya. Rather than allowing our lower court colleagues to manage this high-stakes litigation with the care and attention it plainly requires, this court now intervenes to grant the government emergency relief from an order it has repeatedly defied. I cannot join so gross an abuse of the court's equitable discretion. I mean, if you stop and you think about it, what a middle finger that is given to the lower courts, to the trial court judges that are laboring so hard to be able to come to these rulings. They're the ones that are listening to the arguments. They're the ones that are taking in the evidence and considering the credibility of the people that are making these arguments and the lives that are at stake. And all this federal judge in Massachusetts did was say, whoa, pump the brakes here. We want to make sure that the due process is afforded people before they are sent to third countries. But alas, the United States Supreme Court, supermajority conservative, said, to hell with that, because we don't give a shit. Judge Murphy's preliminary injunction was also a nationwide injunction, and we all know that came to a crashing halt, except for very specific circumstances, by the Supreme Court just a few days later at the end of June. So, considering the background, that legal framework that came out of the Supreme Court allowing these deportations to be renewed, ICE issued this memo. So let's get back to the memo. So here's the triage, here's the structure and the framework, because this is really important for you to understand what's at stake for the people that are currently in detention. If the country, we'll call them third countries, if the third country says that they are providing diplomatic assurances, by the way, this is not defined in the memo, diplomatic assurances that immigrants will be safe in those third countries, then those immigrants are going to be given 24 hours notice that they're being shipped off to those countries. 24 hours notice. Do you think that's enough time to be able to find a lawyer or consult with a lawyer if you even have the benefit of having one? Does that sound like notice and opportunity to be heard? No. Now, if there's an exigent circumstance, again, not defined in the memo, exigent, if there's an emergency, then, and I'm not sure what emergency could possibly exist to deport someone, but okay. If there's exigent circumstances, you will only get 6 hours advance notice. 6 hours. Does that sound like notice and opportunity to be heard? Nope. Now, if that third country has offered assurances that nothing bad will happen to you if you come to that country, you don't get any advance notice at all. I want you to stop and think about the import of this. They're literally saying that if some country offers you some assurances, and what's the guarantee on that, right? That an immigrant will be sent to that third country and that they'll be safe. I promise you, they'll be safe. You get no advance notice at all. Literally, plain bye, goodbye. Boom, 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 boom. Does that sound like due process? It's not. So this is going to impact thousands of immigrants with final removal orders who have not been deported to their native countries because a judge found that they might face danger there. And according to Kristi Noem, dog killer extraordinaire, on Fox News Sunday yesterday, she said that this ICE memo is, quote, incredibly important to make sure we get the worst of the worst out of our country. But we all know that that's a false statement, right? We know that the percentages are as large as 60% that have no criminal convictions and are not criminals here in the United States that are getting deported. Let's remember that, right? So here's what should happen. Immigrants stating a fear of being deported should be screened for possible protection. But here's the problem. Immigration lawyers saying that this plan by ICE doesn't give immigrants enough time to assess the danger that they might face in a country that the government has selected for them. Aha, because that's the key, right? It's not like the immigrants in detention are like, well, are you giving me a menu from which I can choose? Let's look at the drop-down menu of countries to which I can be sent, even though I don't even come from there. So think about that. You don't even speak the language, don't have any family, don't have any friends there, but we're just going to be summarily deported to those countries. So the country, the United States, the United States is going to pick that country for you. Trina Remuto, the executive director of the National Immigration Litigation Alliance, says it puts thousands of lives at risk of persecution and torture. And here's the thing. Simon Sandoval Moshenberg, the lead lawyer on the federal lawsuit that deals with Kilmar Abrego Garcia, says this. It is definitely thousands upon thousands of people. This is a category of people who understood themselves to be out of the woods. So if you have a third country that has not provided a guarantee of safety to an immigrant that's being shipped there, officers are supposed to follow a more limited procedure than the one that Judge Murphy had laid out of notice and opportunity to be heard. So in that instance, in Judge Murphy's case, he said officers should screen the men to determine if they have a legitimate fear of removal, give them access to a lawyer, and at least 10 days to challenge their removals. But that Supreme Court ruling that you and I just walked through a couple of minutes ago, that set aside that process wholesale. It said, you know that Judge Murphy injunction, that process, and it's not going to happen. And so that's why these deportations can resume. And for example, in that case, you had 8 immigrants that were from Cuba, Vietnam, Myanmar, Laos, Sudan, and Mexico that were sent to the active conflict zone of South Sudan. So here's the thing. This memo by ICE's acting director, Todd Lyons, says that ICE can deport someone to a third country that has not offered any safety guarantees within 24 hours of notifying them where they're being sent. Officials will not ask immigrants if they fear being deported to that country. And his memo is based on guidance that Kristi Noem provided in a March memo. Okay? But if you're an immigrant who has expressed a fear of being deported in that 24-hour period, you will be screened for possible humanitarian protection under federal law and the Convention Against Torture, which was ratified by Congress in 1994, which bars the United States government from sending you to a country where you might face torture. But here's the thing, this loosey-goosey language in the memo says screenings will generally, and that's in quotes, generally occur within 24 hours to determine if it merits immigration court proceedings, humanitarian protection, or if you should be deported to another alternate country. So it's not even like you express the concern, you're even given the opportunity to contest it, you're not given enough time of advance notice. But then if they're like, oh, okay, so you don't want to go to this country, we're just going to send you to another country. How is that supposed to give you the time again to be able to contest this? The Lyons memo, this ICE memo, said in exigent circumstances, and again, not defining what's an exigent or emergency circumstance, immigration officers may deport someone as soon as 6 hours after notifying them of the third country. And what in the actual hell could be the emergency that would merit deporting somebody only after 6 hours of notice? In those cases, immigrants must be provided reasonable means and opportunity to speak with an attorney beforehand, and DHS General Counsel or ICE's top legal advisors must approve it. You want to talk about stacking the deck against a detained migrant who's trying to fight against their unlawful deportation? I mean, this is lipstick on a pig again. This is their version of due process, but we all know that this is not constitutional due process, and it certainly is not practical due process, right? I mean, it's one thing to say that I am giving you what is constitutionally guaranteed to you. Notice an opportunity to be heard in terms of the due process. But this is even practical. This is not even affording somebody the ability to have counsel to be able to move forward in an immigration proceeding. And now when you actually stack the deck and you say that DHS General Counsel or ICE's top legal advisor must approve it, my lord, you think they're going to approve it? Kelmar Abrego Garcia had a withholding order that said he was not supposed to be sent back to El Salvador. And where was he sent? El Salvador, to CCOT. Folks, you know, again, the lipstick on a pig is so obvious to us, but I want you to be aware that the Supreme Court of the United States is facilitating this type of conduct. It's facilitating ICE to have color of law, or, you know, this idea that they're cloaked in some presumption of legal credibility when they do these things, because the Supreme Court said, Judge Murphy, your injunction, we're going to stay that injunction so that the appeals process can move along. And the fallacy in that is this was yet another emergency application by the Trump administration. Remember I said on prior Katie Phang News channel videos, it's like a little kid running to hide behind mama's skirts. That's exactly what the Trump administration does with these emergency applications. It runs to hide behind the skirts of the Supreme Court ultra-conservative sits. And when that happens and you have these emergency applications which are granted, and then you get these horrific decisions from SCOTUS, like the one we're talking about right now, then of course ICE is saying, well, we're doing everything legally because the United States Supreme Court said we could do it. So it's just a disservice to justice that we're seeing across the board here. And the fact that this memo has now been issued and this is now the policy and procedure that they are going to move forward with, and ICE and DHS, it doesn't bode well for anybody who is taken into custody. And we all know that it is illegal conduct that is getting people into custody right now. So I can't blame people if they're going to run, and they're going to run scared, and they're going to be fearful of what happens, because before, there was some semblance, I guess, of a process, albeit a slow one and a broken system, but maybe some semblance of a process. But now, there's none. It's total anarchy when it comes to immigration. Or, more accurately, it's whatever the anarchist, fascist Trump administration thinks is the process you deserve. Be mad, be outraged, demand accountability. We're going to keep our eyes on this one as well. Katie Phang here. We launched the Katie Phang News channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.